Velina me ke aloha. Welcome to the Lāhui Rising series. This educational series is designed to create a safe, respectful, and enriching learning space for all audiences to hear and honor various perspectives on matters of Hawaiian interest. The content of the presentation shown in the Lāhui Rising series may not necessarily reflect the views of Kamehameha schools. However, we hope this series will encourage openness and respect for differing views on Hawaiian issues and stimulate discussion and action towards positive change for our Lāhui Hawaii.
Nani nā leo o nā ohana. Aloha mai e nā ohana o Kamehameha, nā ohana o Hawaii nei. Ai, e olu e pule kākou. E ke akua mana loa ma nā lani ki e. Ke akua o ke ali'i pauahi. Ke akua o ke kula o Kamehameha. Ke akua o Hawaii. Ke akua o ka honua nei. Nui ko mākou mahalo ia oe e ke akua no ka mea nauno I hana nā mea mai ka ia pau. Our Heavenly Father, akua of our princess and our school, our Hawaii. We thank you for the verse that speaks of ka Lāhui Hawaii in our Hawaii pono'i. We are thankful for life and opportunities to learn, such as this evening, when our two distinguished doctors, Keanu Sai and Federico Lenzerini, share their mana'o with us. We ask that you open our minds and our na'au to receive information and knowledge, to help us to go forward, to learn more, and to discern, and to make decisions for our ohana, our Lāhui. We ask for forgiveness for our shortcomings, for we are mere human beings. Help us to be humble, to respect one another, as our kupuna have taught us. We ask that you be with us, your spirit, this evening, all the ohana who have come out, that we may share our feelings, we may share our mana'o as well. So ke aku, we just thank you for Kamehameha Schools, Ka'iwa Kilo Moku, our Hawaiian Cultural Center here. We thank you for our school that is a Christian school, that is a Hawaiian school. And at the conclusion of this evening, we ask that you take us home safely with our loved ones. Ke ia maumea e nonoi ha'aha ia oe ke akua, makaino kau ke ki hiva hivo Yesu Christo. Amen.
Enoho Malie, please have a seat. Aloha nui e ka ohana mai ka moku o ke ave I ke kahi ali'i o ka moku, ani I hau o ka hele lani. Aloha nui kākou. Wau ke ia o Manu Boyd. My name is Manu Boyd. I'm with the Ho'okahua Hawaiian Cultural Vibrancy Group here at Kamehameha Schools. O Kamehameha ke ali'i ho'okahi, nana I ho'okumu I ke au puni mo'i. Our Kamehameha is the chief who established the Hawaiian Kingdom. We're here in an unprecedented forum here at Ke'eli Ko'olani, named for Kamehameha's great-granddaughter, Princess Ruth Ke'eli Ko'olani, at the school founded by her cousin, another great-granddaughter of Kamehameha, Ke'eli Pauahi, to discuss issues that pertain to our kupuna. Bernice Pauahi was born in 1831 in the Kingdom of Hawaii. Kamehameha Schools was established by her will in 1884 in the Kingdom of Hawaii. When the government of Queen Iliuokalani was overthrown in 1893, the government of the Hanai baby sister of Pauahi was overthrown. Ano laila ke ia ahi, he hanana ke ia, e ho'ike mai ka no'e au o kahi po e opiopio, a ole opiopio paha. We're here to learn and to experience wisdom that will really take us into a direction that we may not have been before, into places we haven't gone. But before I introduce our speakers for the evening, I'd like to acknowledge the Ka'iwa Kilo Moku Hawaiian Cultural Center. This is a part of our Ka'iwa Kilo Moku Hawaiian Cultural Series. We also acknowledge the Kamehameha Schools Kapalama Social Studies Department, who helped pull this together, and also the generous support of the Charles Parent Fund. Charles Parent and his wife Beatrice Parent came to Hawaii in the 1920s, and Charles became a teacher here at Kamehameha Schools. His wife Beatrice taught also here in Honolulu in Kaka'ako at the Mother Rice Kindergarten, and together they influenced many lives. Their legacy establishing a trust for educational forums such as this, and so we acknowledge that trust as well, the Parent Fund for making tonight's event a possibility. We hope that you're all olu, that you're all comfortable here in this beautiful Ke'eli Ko'olani auditorium. We ask that you listen with your heart, with your mind, and listen to the brilliant ike that has been building and growing. Kukulu ia nohoi. At this time, I'd like to bring up Umi Perkins, Dr. Umi Perkins, who's with the Social Studies Department here at Kamehameha Schools Kapalama. Eo e Umi.
Ke aloha ahiahi kākou. I'd like to just repeat the mahalo to all of those who made this event possible, this quite unique event. It was very much a group effort, so mahalo nui ya oko. The writer Thomas Pynchon wrote, and I quote, "If they can get you asking the wrong questions, they don't have to worry about the answers." This is a challenging idea that should make us think very deeply about how we engage with, among other things, history, and make us ask ourselves if we have indeed been asking the right questions. I'm Umi Perkins, and I teach Hawaiian history here at Kamehameha and political science at the University of Hawaii, so I'm no stranger to controversial topics. I've been teaching many of the topics we'll be discussing tonight for nearly 15 years, and I've managed somehow never to get in trouble. And I think that's why I was asked to open tonight's event. In fact, I was asked recently by another teacher who often gets in trouble for talking about the same things, how I do it, how I stay out of trouble. And it got me thinking, how do I do it? I started to realize that there are ways to discuss the topics we'll be looking at without stirring up controversy. And one of them is to keep the issues more about law and less about politics. I think the way I got into this manner of thinking was by being part of a student organization at the University of Hawaii, which was founded by Dr. Keanu Sai, one of our distinguished panelists tonight. It was called the Hawaiian Society of Law and Politics, or as we called it, HSLP. HSLP was about discussing both law and politics, but in a way that was mindful of the separation between them. The society sought, and to a large extent succeeded, in integrating a lot of these concepts into the curriculum across the UH system and even beyond. So that now, for example, I'm teaching a course on military occupation at UH Manoa, which serves as a kind of a testing ground for the idea of Hawaii as an occupied country by comparing it with other occupations historically. This course was originally created by yet another member of HSLP. More recently, I wrote an article on this topic in The Nation magazine. The Nation is the oldest weekly magazine in the United States. It's 150 years old. I was also hired to rewrite the Hawaiian history standards for the Hawaii Department of Education. Among other accomplishments, Dr. Sai has written a Hawaiian history textbook called Ua Mau Ke'ea. Kamana Beamer, another HSLP member, wrote an award-winning book incorporating this view called No Mako Kamana. And several PhD dissertations and master's theses have been produced that have furthered this line of research, including one thesis by Donovan Preza, again of HSLP, which was named the best MA thesis in the entire Pacific Rim. So a lot has happened since 2001 and the original Larsen case. I think it's very significant that, and very important that as this case returns to the Permanent Court of Arbitration, this time for fact-finding, the level of understanding locally on this topic has been greatly expanded since the time of the original Larsen case. There's a great quote that comes from the sciences that says, "The great thing about science is that it's true whether you believe it or not." And to some extent, that is the case of some of the ideas that we're talking about here. I find that when I speak to people about these ideas, they have a lot of doubt about things that, as a political science, I consider very basic, things like the international system and the way that it works. One of the questions I'm often asked when I talk to people about these issues is there really a world court? Many think that law is a matter that is strictly domestic, that is limited to being within countries. But yes, in fact, there is a world court. There are several organs, if you will. According to their website, the Permanent Court of Arbitration was established by treaty in 1899 and is an intergovernmental organization providing dispute resolutions to the international community. In the same building as the PCA, the Peace Palace in The Hague, Netherlands, where the proceedings we'll be discussing tonight will take place, is the International Court of Justice, which according to their website is the principal judicial organ of the United Nations. It was established in June 1945 by the Charter of the UN and began work in April 1946. Now, the court's proceedings don't often make major headlines. They're often about fairly obscure trade disputes. But one that has made headlines is the case of the South China Sea, that region being a major geopolitical hotspot right now. And for the ruling in that case, they cited the first Larsen versus Hawaiian Kingdom case from the year 2001. So how did it come to be that I began teaching these ideas at a, if I may say so, a fairly traditional institution like Kamehameha Schools? There is, in fact, a genealogy there. Hawaiian history began to be offered at Kamehameha around 1971, but wasn't required until the 1980s. In 1987, when Lāhui, Hawaii was formed, the former Hawaiian history teacher, Kavika Makanani, resolved to make the Hawaiian history course a course on Hawaiian sovereignty as it was understood at the time. In 1993, Kamehameha School's faculty, including Kavika Makanani, former principal Julian Ako, current English department head Kaimi Pono Ka'ivi, and others conducted a research project to discover and expose more about the 1893 overthrow. In the late 1990s, my predecessor in my position, Kehau Abad, incorporated many of the concepts we'll discuss tonight into her curriculum, which I subsequently inherited and continued to develop. By means of comparison, the Hawaii Department of Education began requiring courses in Hawaiian history in response to the 1978 Constitutional Convention, and the department's Hawaiian Studies program began in 1980. Tonight's event is not about taking positions or taking sides. Tonight is really about educating people. And to that purpose, I'd like to conclude my remarks by suggesting what might be done in terms of educating a group of people we all care about. That is Hawaiian youth and the youth of Hawaii more generally. There are serious structural problems in the delivery of Hawaiian history in schools today. To name only one example, to become a certified social studies teacher, you'd have to pass the praxis test, which is a very demanding test in a number of topics, none of which is Hawaiian history. So if you were able to pass that test, it's unlikely, not impossible, but unlikely, that you'd have a deep knowledge of Hawaiian history, and vice versa. If you spent your time learning Hawaiian history as a young teacher, you'd be hard-pressed to pass that test. This is only one of many such structural problems that result, in the end, in a society that doesn't really know and thus has not come to terms with its own history. Seen in this context, tonight's event can be thought of as part of a larger community effort to educate ourselves about these critical historical issues and their ramifications today, starting tonight by beginning to understand the International Commission of Inquiry at the Permanent Court of Arbitration. At this time, as a way of introducing the general topics we'll be learning about tonight, we will show a video. It's quite concise and under 15 minutes in length, after which I will introduce our panelists.
On August 12, 1898, during annexation ceremonies at Iolani Palace, two figures stood on a platform before an international gathering. Sanford B. Dole and U.S. Minister Harold Sewell exchanged treaty ratifications annexing the Hawaiian Islands to the United States, or so it appeared. But was it really a treaty of annexation? And did Hawaii really become a territory of the United States? What is a treaty? A treaty, in its simplest terms, is a contract or agreement between two nations. Under international law and practice, a simple three-step process is all that is required for a treaty to be legal and binding. First, a representative from the executive branch of both governments sign and consent to a written agreement. This signed agreement is then submitted to the two respective countries for ratification or approval. In the United States, that approval is based on a 2/3 vote of the Senate. With both countries having consented to the terms and conditions of the agreement, all that remains to consummate the treaty is for both countries to exchange copies of the ratified agreement. That agreement, under international law, is now considered a bona fide and legally binding contract or treaty. In 1849, a treaty of friendship, commerce, and navigation between the United States of America and His Majesty Kamehameha III had been concluded and signed at Washington. Ratification by both countries were exchanged in Honolulu on August 24, 1850, and the treaty was enforced from that date for the term of 10 years and further, until either party gave notice to the other of its intention to terminate. By the late 1800s, the Hawaiian Kingdom enjoyed the distinction of being a member of the family of nations, having entered into treaties with 20 foreign powers. Immediately following a treasonous attempt to overthrow Queen Liliuokalani in January of 1893, enemies of the kingdom, now calling themselves the Provisional Government, departed for Washington, D.C. to sign a treaty of annexation with the United States. Their sole intention was to achieve annexation at any cost. However, before the United States Senate could ratify the proposed treaty, newly elected President Grover Cleveland, confronted with the facts of the overthrow, withdrew the treaty from further consideration and vowed never to allow the Treaty of Annexation to be resubmitted. Having failed at this first attempt to obtain a treaty of annexation with the United States, the Provisional Government on July 4, 1894, declared itself to be the Republic of Hawaii and maintained its opposition to the restoration of the Hawaiian Kingdom government, as called for by President Cleveland. On June 16, 1897, with Grover Cleveland now out of office, a second effort to annex the Hawaiian Islands to the United States was attempted. A treaty was signed in Washington, D.C. between representatives of the self-proclaimed Republic of Hawaii and the newly elected President of the United States, William McKinley. The following day in Washington, Her Majesty Queen Liliuokalani submitted a formal letter of protest to President McKinley, asserting that this proposed treaty of annexation violated the existing Treaty of 1850 between the Hawaiian Kingdom and the United States.
Because said treaty ignores all professions of perpetual amity and good faith made by the United States in former treaties, it is thereby in violation of international law. Therefore, I, Liliuokalani of Hawaii, do hereby call upon the President to withdraw said treaty from further consideration. I ask the Honorable Senate of the United States to decline to ratify that treaty.
Word of what had transpired in Washington soon reached the islands. Anticipating that the U.S. Senate would reconvene in December to consider this second attempt at annexation, an aggressive campaign was initiated, intending to fortify the Queen's second letter of protest. On September 6, 1897, James Kaulia, president of the Hui Aloha-Aina, the Hawaiian Patriotic League, gave a stirring speech before thousands at Palace Square in Honolulu. He said agreeing to annexation was like agreeing to being buried alive. He asserted that a mass refusal by the people could prevent annexation.
Let us take up the honorable struggle. Do not be afraid. Be steadfast in aloha for your land and be united in thought. Protest forever the annexation of Hawaii until the very last patriot lives.
On petition to the President, Congress, and people of the United States, otherwise known as the Monster Petition, was read and approved at this rally, asking that no further steps be taken toward the ratification of the treaty. The men and women of the Hui Aloha Aina, through the efforts of many loyal and dedicated Hawaiian subjects, launched a full-scale petition drive that lasted approximately 2 months. They went from island to island, from shore to shore, leaving no stone unturned in their efforts to document opposition to the proposed treaty. The petition was printed in both English and Hawaiian.
We, the undersigned, native Hawaiian subjects and residents who are members of the Hawaiian Patriotic League of the Hawaiian Islands and other citizens who are in sympathy with the League, earnestly protest against the annexation of the Hawaiian Islands to the United States of America in any form or shape.
By November of 1897, they had successfully gathered the signatures and support of over 21,000 patriots. In a joint effort, the Hui Kalai Aina also gathered through their petition drive nearly 17,000 signatures. Together, there were over 38,000 signatures, representing 95% of the native Hawaiian population. James Kaulia, David Kalaukalani, John Richardson, and William Auld traveled to Washington to deliver the petitions to the United States Senate. In December, while they watched from the gallery, the text of the monster petition was read on the floor of the Senate, and the signature petitions were formally accepted. As a result of these protests from the Queen and her people, the United States Senate failed to obtain the required 2/3 vote as mandated by the U.S. Constitution to ratify a treaty. By March of 1898, the Treaty of Annexation was dead. But expansionists in the United States Congress, led by Senator Morgan, would not let the dream of annexation die. Within days, they devised a plan to bypass the requirements of their own constitution in an effort to annex Hawaii.
The Hawaii Annexation Treaty lags in the Senate. The number of votes needed will not come forth. The advocates of the scheme are now preparing to resort to a joint resolution, which may be put through by a simple majority in each House of Congress. In other words, if Congress should strictly obey the Constitution, annexation could not take place.
In March of 1898, they introduced Joint Resolution Number 55 to provide for annexing the Hawaiian Islands to the United States. The joint resolution, otherwise known as the Newlands Resolution, was then passed by a simple majority in each House of Congress and signed by President McKinley on July 7, 1898. This was the document presented by U.S. Minister Harold Sewell to Sanford Dole at the annexation ceremony in August of 1898. Dole responded, "I now yield up to you, representing the government of the United States, the sovereignty and the public property of the Hawaiian Islands." For the past 100 years, it was assumed that Joint Resolution 55 possessed the power and effect of a treaty. However, according to international law and practice, it did not. Moreover, under U.S. constitutional law, a joint resolution does not have the power to extend beyond the borders of the United States. Without a treaty of annexation, American sovereignty cannot exist in these islands. Nothing has legally transpired which could affect the lawful existence of the Hawaiian Kingdom and its subjects. There was no annexation.
No, Another man broke his word. Another man broke his word. Ooh, another man broke his word. And the truth could not be heard. Somebody's gonna have to pay. Oh, somebody's gonna have to pay. Somebody's gonna have to pay. And it looks like you and me. When I see that rain fall from the sky, oh, when I see that rain fall from the sky, oh, when I see that rain fall from the sky, I get down on my knees and I cry. Another man broke his word. Another man broke his word. Oh, another man broke his word. And the truth could not be heard.
Our first presenter really needs no introduction, but Dr. Keanu Sai has a PhD in political science from University of Hawaii, specializing in international relations and public law. He has taught extensively throughout the University of Hawaii system and presented even more extensively throughout the world, including at the University of Cambridge, Harvard University, New York University, and Smithsonian Museum in Washington, D.C. He's the author of the textbook Ua Mau Ke Ea and numerous academic articles, including a book chapter soon to be released by Oxford University Press. Please welcome Dr. Keanu Sai.
Aloha mai kako. It's an honor to be here, a privilege. I'm also a graduate of the Kamehameha Schools, 1982. The last time I was here was in high school. So what I'll be doing is the presentations that myself and Federico will be presenting are very procedural. It's to provide a basis for everyone to understand. It's not really about the Hawaiian Kingdom's existence, but about international proceedings that address and acknowledge the Hawaiian Kingdom's existence. So it's a very different presentation that some of you may be or may have never had before. So before I can provide a better understanding of the Permanent Court of Arbitration and the proceedings that have taken place from 1999 to 2001 and that have been reinitiated this past year, we need to understand the difference between national laws and international laws. So here we have the two countries, the Hawaiian Kingdom and the United States. In 1898, the United States passed a law called the Joint Resolution of Annexation. That law is an American law, or what we call national law, as opposed to international law, which is a law between nations. A national law is limited to effect within a nation. 2 years later, the United States Congress passed another law called the Organic Act, establishing the territorial government, or just changing the name from the Republic, which used to be the Provisional, which used to be the Hawaiian Kingdom. Merely name change. But again, to stress the point, this is a national law of the United States. Then in 1959, the United States Congress passed another law changing the name from the territory of Hawaii to the state of Hawaii. And then in 1993, the United States Congress passed a law apologizing for the illegal overthrow of the Hawaiian Kingdom government. But within that apology law, they used terminology that is very similar to and a part of what is called federal Indian law. So terms such as indigenous people, self-determination, that's the terminology that applies to within the federal Indian law, which is within the United States law. And then in Act 195, 2011, Kana Iolowalu. Okay. Now, what we have as far as the genealogy of all these laws is that they are U.S. laws. Now, U.S. laws have no enforcement in another country. Okay, so the United States in 1898 could no more pass a law annexing Hawaii than it could pass a law today annexing Canada, because it's limited to its territory. And that's part of U.S. constitutional law, a very recognized principle at that. Now, these are Hawaiian Kingdom laws that existed in 1893 that the Queen and our kupuna were under, such as James Kaulia, David Kalaukalani. Yeah? Now, Hawaiian law is limited. These are national laws limited to Hawaiian territory. Those are American laws limited to American territory. So just as American laws cannot be applied in Kapahulu, Hawaiian laws cannot be applied in Orange County, California. They're separated by international law. And that goes to the basis of Hawaii's status at that time as a sovereign and independent state. But international law, which is not national law, international law is a law between nations, and that's what we call treaties, customary international law. In this case, what regulates Hawaii's situation is the international laws of occupation, which is the Hague and the Geneva Conventions. So the United States Supreme Court, this is the authority of U.S. law, okay, within the United States. And it specifically states here, back in 1824, in the case the Apollon, the laws of no nation can justly extend beyond its own territories. They can have no force to control the sovereignty of any other nation. In 1936, the United States Supreme Court reiterated that position and said neither the Constitution nor the laws passed in pursuant of it have any force in foreign territory. So here's a visual to explain this. This is the United States of America. What you have there is Washington, D.C., where the U.S. Congress is situated. You have borders. U.S. laws have no effect beyond the borders of the United States. Now, in 1988, the United States Department of Justice, the Office of Legal Counsel, stumbled over this information or these facts in a legal opinion that was referring to whether or not or how could the United States extend the territorial seas from a 3-mile limit from the low water mark off the coast to 12 miles, right? Because the U.S. Congress is limited to the territory, but also a 3-mile extension in the ocean. That's called territorial sea. The question was whether or not Congress could extend that 3-mile limit to add on 9 miles. But that became a problem if it's only limited to the 3-mile limit. And that's what this legal opinion was covering. And it uncovered a particular part of history that they did not know, and it concerned Hawaii. So in that legal opinion, it said, despite the constitutional objections, Congress approved the joint resolution, and President McKinley signed the measure in 1898. Nevertheless, whether that action demonstrates the constitutional power of Congress to acquire territory is certainly questionable. And they concluded it is therefore unclear which constitutional power Congress exercised when it acquired Hawaii by a joint resolution, thus understanding the fact that U.S. laws have no force and effect beyond its borders. So I could say here that the U.S. Attorney General was befuddled, to say the least. I like to say they go from the OMG to the WTF. And I didn't have to say what WTF is. I just want to say Keith Olbermann made it okay to say WTF when he had Current Affairs on MSNBC, so I'm okay. So what we have to do here is we have to reassess Hawaii's position in order to know what rules to follow. So if the U.S. Constitution is limited to U.S. territory, and the United States Department of Justice cannot figure out how Hawaii was annexed by U.S. law, then what rules apply to Hawaii's situation? Because Hawaii was an independent and sovereign state, it still is. And that's why we need to start to apply the appropriate or correct rules. So according to the U.S. Supreme Court, we use them as a guide, it says that when the United States is in foreign territory, it must be governed by treaties, international understandings and compacts, and the principles of international law. That's pretty much the framework that needs to be understood with regard to these facts of our history, our country. The international law that applies to Hawaii is humanitarian law, which is the law of occupation. And that is the Hague and Geneva Conventions. Now, some people might say, well, the Hague Convention was 1899. The Geneva Convention was 1949. Well, that's after 1893. It is recognized explicitly throughout international law that the Hague and Geneva Conventions were merely codifications of customary international law. In fact, it's part of the dialogue when the parties or these countries got together to actually create and form the Hague and Geneva Conventions. So it was understood that these were already accepted as law. So they weren't creating new law, the law of occupation, they were merely codifying the law of occupation. So the legal presumption of continuity, another principle of international law. So Hawaii, a recognized independent state in the 19th century, so presumably Hawaii today remains a sovereign state because international law provides for the presumption. What this means is the presumption of international law, the presumption of the continuity of a country under international law takes into consideration that even though a government might be overthrown, that does not equate to the overthrow of that sovereign state. And it is presumed to still exist. An example of that would be 2003 Iraq. In 2003, the United States military overthrew Saddam Hussein's government. But by overthrowing the government, Iraq still existed as a state. That came under this legal principle, the presumption of continuity. Now, what the presumption of continuity also provides is because it's a legal principle, it has the effect of shifting the burden. So if it is the presumption of continuity that is there, it is up to another party to prove or disprove that continuity. No different than how you would look at the presumption of innocence. A person that is presumed innocent does not prove they're innocent. It's the other party that has to prove their guilt beyond the reasonable doubt. That's where that principle comes from. Now, that presumption could be rebutted if the United States extinguished Hawaii's sovereignty under international law, which only recognizes treaties, not U.S. laws. So now you can further understand how befuddled the United States Attorney General was in 1988. So today, Hawaii would still exist as an independent state. The problem is nobody knew that. But the presumption and international law is what preserves that status, whether we believe it or not. It's really now just a matter of trying to understand it. So what do you do in this situation? Well, there were certain steps that were taken in light of the fact that since 1893, there has been no lawful government in Hawaii. No lawful government. All the governments that came were, I guess, declared in Hawaii after 1893 were all based upon U.S. law from the United States Congress. If the United States Congress has no effect in Hawaii, then these governments cannot claim to be real governments. So, from a legal standpoint, since 1893, there has been no lawful government. Also, international humanitarian law does not allow elections during occupations. Okay? Well, deliberate steps were taken in light of this, where elections cannot take place during occupation, to basically establish or reestablish a government similar to how governments were established during World War II as governments in exile. And this is based upon what is called necessity, which I'll be getting into. So in 1995, a provisional government was established to represent the Hawaiian Kingdom, called the Hawaiian State, in international law. Now, governments that are created by necessity or governments in exile do not represent the people of the country because they're not elected. What they do represent is the state, okay? And that's what governments in exile represented. During World War II, the Belgian government in exile represented Belgium, but yet that government in exile was in London. They did not represent the people, they represented the state, and their job was to ensure that the Germans, when they occupied Belgium, followed the law. And this principle relied on the legal doctrine of what is called necessity. And this is something that I'm very familiar with as a retired captain in the Army, because a private can become a lieutenant under the doctrine of necessity if everyone in the chain of command is killed. And it is his duty to assume the chain of command, not his choice, his duty in order to maintain the command structure. But he is only an acting lieutenant until a properly commissioned officer comes, relieves him, and he goes back down being a private. That's how it works. That's how we did it in the Army. That's how governments in exile, they did the same thing along the same principles. So the legal doctrine of necessity, this is the doctrine. Okay? Specifically, it says, an imperative necessity must arise of the existence of exceptional circumstances not provided for in the Constitution, for immediate action to be taken to protect or preserve some vital function of the state. There must be no other course of action reasonably available. Actions taken must be necessary in the interests of peace, order, and good government. It must not impair the just rights of citizens under the Constitution, and most important, it should not have the intention of consolidating power, because when you assume the role of government, the law says that's treason. It is the necessity principle that allows it in light of that. Yeah? So that's the law of necessity. So here we have the Hawaiian state of the Hawaiian Kingdom, fully recognized. Its government was the Hawaiian Kingdom government of our kupuna. Queen Lili'uokalani was executive monarch. That government was illegally overthrown, but by overthrowing the government, it did not overthrow the country. And the provisional government merely took its place. Now, what is the provisional government? Well, the purpose of the provisional government is, one, to expose the prolonged and illegal occupation of the Hawaiian Kingdom by the United States, to ensure that the United States complies with the laws of occupation, which includes the Hague and Geneva Conventions, and to provide for an effective transition for governance under Hawaiian law when the occupation ultimately comes to an end. Now, this narrative that I just presented to you will be tested at the Permanent Court of Arbitration in the Netherlands in 1999. Now, the Permanent Court of Arbitration, as Umi had pointed out, was established in 1899 by the Hague Convention number 1. And in this, at the Permanent Court of Arbitration, they provide services to resolve disputes. Now, the Permanent Court of Arbitration is an intergovernmental organization. Their job is to create tribunals to address particular disputes, in particular, ad hoc tribunals. You don't have standing tribunals, ad hoc. Yeah? And once they receive a dispute, they first have to determine whether or not it is an international dispute, because private people cannot go to the Permanent Court of Arbitration. One of the parties has to be a state. A state. Remember that diagram I showed you? The Hawaiian state still exists despite the government being overthrown. So the Permanent Court of Arbitration will exercise institutional jurisdiction before they create the tribunal. They will create a tribunal when they verify that you have two states. In this case, this is from the case repository of the Permanent Court of Arbitration. This is between Ecuador and the United States of America back in 2012. If you notice, to the bottom, the Permanent Court of Arbitration identifies Ecuador as a state and the United States of America as a state. Then they create the tribunal, and then they go through the dispute. Now, what the tribunal will address is a different type of jurisdiction. That's called subject matter jurisdiction. What the Permanent Court of Arbitration addresses is whether or not this state actually exists. Not in theory, it has to exist in fact, because if it doesn't exist in fact, it can't have a dispute to create a tribunal. The second type of tribunals that will be created when they need to determine whether or not a state has a dispute with an international organization. And in this case, on the case repository, you will notice that this is Peru versus the United Nations. They verified that Peru is a state, and then they verified that the UN is an international organization. Then they created the tribunal. And this is the case that I was a part of, Larsen versus the Hawaiian Kingdom. They also can hear cases or establish tribunals between a state and a private entity. So there's the Larsen versus the Hawaiian Kingdom, case repository. If you notice, they identify Lance Paul Larsen as the private entity and the Hawaiian Kingdom as a state. This is very profound. This just verified what we had thought, right? Now, the next step is, well, who's the entity that represents the Hawaiian state in the arbitral proceedings? So you can have a state. The question is, are you a legitimate government that can represent the state? This is what the Permanent Court also looks at. And if you notice, once they established the tribunal here, which are these three names, the arbitrators, two of those arbitrators actually now serve as judges on the International Court of Justice, selected by the United Nations. So the caliber of this tribunal is quite amazing. And if you notice, it says representative of the claimant, Lance Larsen, Ms. Parks, and representative of the respondent, which is the Hawaiian Kingdom. That's me there as the agent. So I was in charge of the legal team, and that's what an agent means. So here we are at the Permanent Court of Arbitration during oral hearings in the year 2000, December. Now you have to keep in mind, this is not the Hawaiian Kingdom case. This is actually Lance Larsen coming after the Hawaiian Kingdom for not protecting him because he went through a trial and incarceration under American law. So his attorney was alleging that the acting government, the provisional government, was negligent for allowing American laws to be imposed in Hawaii, which led to her client's incarceration. That's the issue that was taken to the court. Now, what Lance Larsen had to deal with was whether or not the tribunal, not the court, the tribunal could proceed. Now, this is the jurisdiction of the tribunal, not the Permanent Court of Arbitration, to determine whether or not they could proceed without the United States participating, because it was the United States that arrested Lance Larsen and put him on trial and incarcerated him. It wasn't the acting government. So they had to first deal with whether or not the conduct of the United States was lawful. And if it violated Lance Larsen's rights, then they could move to hold the Hawaiian Kingdom accountable, but that would still be part of the proceedings. So let me share with you a 4-minute clip of the actual proceedings held at the Permanent Court of Arbitration.
The dominion of the Hawaiian Kingdom. In a summary, from 1840, the Hawaiian Kingdom possessed a constitutional government with elected and appointed officials and a complete system of civil and criminal laws to govern Hawaiian territory. On April 8, 1842, King Kamehameha III and Privy Council commissions 3 envoys to secure international recognition of Hawaiian independence. And these individuals are Timoteo Ha'alilio, William Richards, and Sir George Simpson. On December 19, 1842, Hawaiian envoys secured United States President Tyler's recognition of Hawaiian independence. November 28, 1843, the British government and the French government formally enter into a declaration recognizing Hawaiian independence. In our pleadings, we refer to that as the 1843 Anglo-Franco Proclamation. From that point, Hawaii has had its statehood recognized as being independent. As such, it began to enter into these treaties: Austria-Hungary, Denmark, France, Germany, Great Britain, Italy, Japan, Netherlands, Russia, Spain, and the United States of America. International recognition is evidence that the Hawaiian Kingdom had diplomatic representatives as of 1893 from those countries, as far as consulates and embassies. Rather, what we find is that the United States has never expressed itself as an occupier. Who would? They will never admit to occupation. But yet, to admit to occupation is, in a sense, to admit to the continued existence of the Hawaiian Kingdom as an independent state, which is really the crux of the matter, which is actually what is holding up, you might say, this issue to be resolved. Thus, the legal order, thus the reestablishment of the government, thus the relationship between its nationals.
I mean, to be slightly unkind, but thus the issue in rem. The point is that if the Hawaiian Kingdom continues to exist, its existence is in rem. It's not in personam. The Hawaiian existence, the Hawaiian Kingdom doesn't exist solely in the opinion of Mr. Larsen.
Right. But that existence should not be dependent upon an occupier, because you basically put the occupier on an equal footing with the Hawaiian Kingdom in its own territory. So really what needs to be addressed is what came before the occupation, whether the statehood or whether the legality or illegality of the Hawaiian Kingdom, not the illegality or legality of the United States as an occupier. Should the tribunal find it has jurisdiction, we are prepared to submit an offer of proof. We felt that this tribunal would offer some clarity so that for the first time we have a third party to present these type of merits that can be scrutinized by international law, rather than taking it before a United States tribunal, which could not rule on it to the detriment of itself. So in that sense, there is really no other way to address this issue. And the opportunity did arise because it was Mr. Larsen who was adhering to Hawaiian Kingdom law. And if the United States was adhering to occupation, not whether they're illegal or illegal, but if they were adhering to the laws of occupation, we wouldn't be here right now.
Well, that was a long time ago. Did you know I still have that same suit and it fits? So what came out of this, the court? So what the court did was it verified that Hawaii was an independent state in the 19th century. Okay? Now with regard to whether or not Lance Larsen can sue the acting government for not protecting him, let me read this to you. It stated, it follows that the tribunal cannot determine whether the respondent, the Hawaiian Kingdom, has failed to discharge its obligations toward the claimant, Lance Larsen, without ruling on the legality of the acts of the United States of America. This is centering on the trial of Lance Larsen and his incarceration. Yet this is precisely what the monetary gold principle precludes or prevents the tribunal from doing. As the International Court explained in East Timor, another international court case, the court could not rule on the lawfulness of the conduct of a state called the Hawaiian Kingdom when its judgment would imply an evaluation of the lawfulness of the conduct of another state which is not a party to the case. The biggest confusion that has taken place with people looking into this arbitration decision, they thought that it was about whether or not the Hawaiian Kingdom exists. No. We were there arguing this case before the tribunal because the Hawaiian Kingdom exists. The Permanent Court of Arbitration would have never started it from the beginning unless they could verify the kingdom's existence. This was a dispute between Larsen and the Hawaiian Kingdom. But what the court also said was the tribunal, the arbitral tribunal said, well, possibly you can get around the indispensable third party rule if you go to fact finding. So it stated at one stage of the proceedings, the question was raised whether some of the issues which the parties wish to present might not be dealt with by way of fact-finding process. In addition to its role as facilitator of international arbitration and conciliation, the Permanent Court of Arbitration has various procedures for fact-finding, both as between states and otherwise, a state and a private entity. Now, we did not take up that issue at that time because of money constraints. The cost of these proceedings that Lance Larsen bore the responsibility to pay, because he was coming after the acting government, went in excess of $150,000. In excess of $150,000. Now, what's interesting is just last year, the South China Sea case, that's about China building islands in the middle of the South China Sea. Yeah. Did you know this case, which has Philippines a state, China a state, did you know that the cost of this arbitration was $30 million? Who bore the cost? The Philippines. So that gives you an idea that it's not cheap to resolve your disputes, right? So what we decided to do otherwise was to begin education. So after we returned from The Hague, that is when I entered the University of Hawaii Political Science Department, enroll as a graduate student, and get my master's degree in political science, specializing in international relations, and then follow with a PhD and provide a way to fix the problem. And since then, a lot of research has been done, which Dr. Umi Perkins has already alluded to in the introduction. But what's more important here with this South China Sea case is not necessarily the $30 million costs, but they also address the indispensable third-party rule. And up to that point, the only precedent cases on the indispensable third-party rule would be Monetary Gold, removed from Rome in 1943, and the East Timor case, which both were cited in the Larsen Award. Well, this is the decision made by the South China Sea Tribunal. Paragraph 181 of its award on jurisdiction. The present situation is different from the few cases in which an international court or tribunal has declined to proceed due to the absence of an indispensable third party, namely Monetary Gold, which you saw was cited in the case, in the arbitral award for the Hawaiian Kingdom, East Timor, another one cited, and Lance Larsen versus Hawaiian Kingdom. So the Lance Larsen versus Hawaiian Kingdom case is a recognized principle now that is used in all international law cases that come before the international court or tribunal with regard to the indispensable third party. So this speaks to the legitimacy and the authenticity of the case itself, despite the misunderstanding and misconceptions that have taken place from people here in Hawaii. But they understood what it was, and that's why at the university we teach exactly what happened at that point. So this clearly shows, in the South China Sea case, they recognize the Hawaiian Kingdom still exists, and it was a citation that they relied on. I would like to end this presentation, my portion, with a famous quote from Donald James Wheel, also known as Dresden James. When a well-packaged web of lies has been sold gradually to the masses over generations, the truth will seem utterly preposterous and its speaker a raving lunatic. Some people thought I was a lunatic. Mahalo.
I'd just like to say that we're truly honored to have as our guest tonight someone of very high caliber. Dr. Federico Lenzerini is professor of international law at the University of Siena, Italy. Is a PhD from the University of Bari and is also a professor at St. Thomas University in Florida in the School of Law in the LLM program in intercultural human rights. He's been a consultant to UNESCO. He's the author of 5 books, 2 from Oxford University Press, and get this, over 90 academic articles. I should also mention that he will be the counsel and advocate for the Hawaiian Kingdom, or he is the counsel and advocate for the Hawaiian Kingdom in the Fact-Finding Commission of Inquiry. Please welcome Dr. Federico Lenzerini.
Aloha mai kaku. Well, it's a real honor for me to participate in this event tonight in front of you. I'm sure that it was worth doing a long journey to be here tonight. As regards my portion of the speech, I will continue from the point where Dr. Sai stopped in order to provide you with a full picture of what happened, what is happening, and what will happen in the future with the Hawaiian Kingdom and the Permanent Court of Arbitration. So my portion of the speech will deal with the fact-finding proceedings which has just been initiated by the Hawaiian Kingdom in front of the Permanent Court of Arbitration. So, on January 19, 2017, just a few weeks ago, the Hawaiian Kingdom entered into a special agreement with Lance Paul Larsen to form an international commission of inquiry, which I will define the Commission, under Part 3 of the 1907 Hague Convention for the Pacific Settlement of International Disputes. The special agreement was transmitted to the Permanent Court of Arbitration International Bureau by myself on January 24 with the notification of the intention to establish the Commission. Now, it is opportune to precise that within the framework of the Permanent Court of Arbitration, 2 options to form a fact-finding commission exist. The first option is the one established by the 1907 Hague Convention, which I have just mentioned, while the second is regulated by the optional rules for fact-finding commissions of inquiry that I will refer to as optional rules. So these 2 options are quite similar with each other, but at the same time they're different because they provide 2 separate avenues to rely on fact-finding. And the International Bureau of the Permanent Court of Arbitration provides assistance in both cases. So whatever will be the option selected by the parties will enjoy the assistance of the International Bureau of the Permanent Court of Arbitration. Now, the special agreement to which I referred supersedes and replaces another special agreement which can be stipulated by Larsen and the Hawaiian Kingdom in 2016, on August 22nd. The previous special agreement was deemed to rely on the optional rules, while the new special agreement, on the contrary, relies on the Hague Convention, on the fact-finding established by the Hague Convention. So, by virtue of the new special agreement, the system of the optional rules has been replaced by the system established by the Hague Convention. So, in the end, Mr. Larsen and the Hawaiian Kingdom decided to rely on the option provided by the Hague Convention of 1907. Now, this is an excerpt from the arbitral award of 2001, which has already been shown by Dr. Sai. So, I'm re-showing this special excerpt because I would like to emphasize again that the decision to establish fact-finding is in response to the recommendations of the arbitral tribunal in the Larsen Award. One important point relates to the costs of fact-finding. Dr. Sai has just explained that an international dispute usually bears huge costs. And sometimes one of the most difficult points to be decided is who has to bear this cost. In the case of the fact-finding proceedings, according to Article 6 of the Special Agreement of January 19 of this year, the Hawaiian Kingdom has committed to bear the burden of costs for the fact-finding. But there is a reason for this decision. The reason is due to the fact that Mr. Larsen bore the cost of the arbitration proceedings, which amounted in excess of $150,000, as Dr. Sai said. So, the Hawaiian Kingdom, in order to speed up the process leading to fact-finding proceedings, has already paid the advance deposit of $10,000, which is required under Article 7 of the Special Agreement in order to institute the International Commission of Inquiry under the auspices of the Permanent Court of Arbitration. And this deposit has already been made to the Permanent Court of Arbitration account. Now, this is another point that I would like to reiterate, but has already been explained by Dr. Sai, which concerns the standing of the Hawaiian Kingdom in front of the Permanent Court of Arbitration. And again, we need to rely on the previous arbitration of the Larsen case. Dr. Sai explained that there are three different options in front of the Permanent Court of Arbitration when it comes to the establishment of arbitral tribunals. The first option takes place when there is a dispute between two states. The second option is when there is a dispute between a state and an international organization. And the third option concerns a dispute between a private entity and a state. In the Larsen case, Mr. Larsen obviously was qualified as a private entity, while the Hawaiian Kingdom was defined as a state. You can see that the term state is properly emphasized, just to reiterate that the status of the Hawaiian Kingdom in these proceedings is that of a sovereign state. This is the old version. This is not my responsibility, okay? because I sent a new version, but probably there has been a mistake. Okay. In the fact-finding proceedings, there is a procedure to be followed. Now, first of all, it is necessary to form the commission. The commission will sit at The Hague in the Netherlands. Of course, you know very well that The Hague is the place where the Permanent Court of Arbitration is located, at the Peace Palace, together with the International Court of Justice. So, when a fact-finding commission of inquiry is formed under the auspices of the Permanent Court of Arbitration, in theory it is possible to decide that the commission will sit in any other place. But since the parties have to use the International Bureau of the Permanent Court of Arbitration, the best choice is to establish the commission at The Hague. Under a logistical point of view, this is the best option, and it is also good to reduce the cost of the proceedings. So, the commission shall consist of 3 commissioners who will be selected by an appointing authority. This appointing authority should be a person of high profile under the perspective of international law and will be chosen by agreement by the parties. This is the next step to be accomplished at this point, and most likely it will be accomplished within the next few weeks. As I already said, the Permanent Court of Arbitration International Bureau will take care of communications between the parties and will assist with all logistics related to the work of the Commission. Continuing with the procedure, during the whole length of the proceedings, the parties will cooperate in good faith with the Commission and between themselves. This is established by the special agreement. Okay. We'll have access to all documents, and we have the opportunity to present evidence and call witnesses and experts. The Commission, after notice to the parties, will be free to consult impartial expert of its choice at any time during the proceedings. All matters relating to the fact-finding proceedings, including the Commission's final deliberations and findings, shall be made public. This is an important aspect, to be precise, because the choice of whether or not, especially the final deliberations of a Commission of Inquiry, are to be made public, is a choice of the parties. So, this is possible thanks to the agreement which has been reached by Mr. Larsen and the Hawaiian Kingdom. The fact of making the final deliberations of the Commission public is certainly positive because it allows to the controversy to attain international visibility. In substantial terms, what are the issues before the Commission? Of course, what I'm going to say right now is the starting point of the work of the Commission, and at this time it is impossible to foresee what the Commission will decide and what the Commission will deliberate. But for sure, the Commission will have to decide on these points. First of all, it should determine what is the function and role of the government of the Hawaiian Kingdom in accordance with the rules of international humanitarian law. Second, it should assess, again on the basis of the rules of international humanitarian law, what are the duties and obligations of the government of the Hawaiian Kingdom toward Lance Paul Larsen, and a fortiori toward all Hawaiian subjects residing in Hawaii and abroad, and finally, towards aliens who, when they visit Hawaii, like myself, for example, are subject to regulations in force in the Hawaiian territory. Okay, I can proceed with this. It seems that today technology is abandoning me. Okay. Now, so the parameter of reference which should be used by the Commission in order to issue its deliberations is international humanitarian law. International humanitarian law has already been mentioned by Dr. Said, who has also explained what is the purpose of international humanitarian law, but I will tell you a few more words. Now, it is a special branch of international law regulating the conduct of armed conflicts. International humanitarian law originated in 1815 at the Vienna Congress, when the European powers realized that sometimes war was unnecessarily cruel, and it was possible to enter into armed conflicts and at the same time reducing the suffering of people. So the purpose of international humanitarian law is that of limiting the effects of war through protecting civilian persons, prisoners of war, and regulating the means and methods of warfare. In a word, its goal is to try to mitigate human suffering during armed conflicts. And when I say during armed conflicts, I also include military occupation, even in the event that military occupation is not characterized, takes place without any resistance from the occupied country. Okay? Now, international humanitarian law, as I said, as an idea, originated at the Vienna Congress of 1815, but it was first regulated by the Geneva Convention for the Amelioration of the Condition of the Wounded and Sick in Armed Forces in the Field of 1864, by the Hague Conventions of 1899 and 1907, and subsequently by the Geneva Conventions of 1949 and their 1977 protocols. All these instruments are treaties, and according to international law, treaties are only binding for states which accept the obligation included in their text. But all these treaties represented a codification of pre-existing customary international humanitarian law. Customary international law is made up of rules of oral character, generally accepted as law and respected by states, which are binding for all countries in the world. So, this makes a huge difference, because while the rules of those conventions are only binding for states which have ratified the convention themselves, the corresponding rules of customary international law, which have had the same content and pre-existed the convention, are binding for all countries in the world. So, obligations under international humanitarian law already existed before the establishment of those conventions, and already before those conventions, they had binding effects for all countries in the world. Now, in the event of serious violations of international humanitarian law, there are two different forms of international criminal responsibility. So, first of all, we have individual criminal responsibility, which under international law is an exception, because as Dr. Sai emphasized, international law is the law which regulates the relationships between states. So the subjects of international law are states, and when there is a violation of a rule of international law, is the state to be responsible. But when it comes to international humanitarian law, we are talking about the most heinous crimes which can be committed by human beings, like genocide, like torture, like extermination, slavery, rape, etc. So, since these violations are considered as totally intolerable by the international community as a whole, as a way of exception, also individual criminal responsibility exists. So, individual perpetrators of violations may be, in certain conditions, prosecuted and sentenced applying the relevant rules by international law, by both domestic and international courts. Then we have another profile of responsibility, which is state responsibility, so the responsibility of the state, which is additional to individual responsibility and exists when international crimes are organized, perpetrated, controlled, or tolerated by governmental authorities who would have the power to control the actions of perpetrators. So, for a state to be responsible, it is sufficient that the states will have the power to stop the violation, but does not do that and tolerate the perpetration of the crime. And this happens in the majority of cases when serious violations of international humanitarian law are committed. Among the most serious violations of international humanitarian law, war crimes are included. Now, war crimes are grave breaches of the laws and customs of war perpetrated during an armed conflict or in case of military occupation, and I repeat, even in the event that the occupation has taken place without any resistance, any military resistance from the occupied state. As far as Hawaii is concerned, war crimes in the occupation of the Hawaiian Kingdom might include, among others, denationalization, destruction of civilian property, pillage, destruction or appropriation of public property belonging to the occupied state, omission of administering the laws of the occupied country, depriving individuals of a fair and regular trial, unlawful deportation, transfer, or confinement. So this issue of war crimes will inevitably go in front of the Commission, of the International Commission of Inquiry. And the Commission will have the duty, as we have said, as we have seen, to assess whether in the Hawaiian territory the rights of Mr. Larsen and of other Hawaiian citizens and aliens have been breached, taking as a legal parameter of reference the rules of international humanitarian law. So, as a consequence, this assessment, as I was saying, will include an investigation of whether during the last decades war crimes have been committed in the Hawaiian territory. Now, At this moment, it is impossible to foresee which will be the substance of the findings of the Commission in this respect. But we can be sure that they will provide a very important contribution to shed a light on the truth concerning the recent history of Hawaii. If one more minute is allowed to me, I have to say that this is probably the most important outcome to be pursued in this moment. Because in order to achieve whatever goal, knowledge, consciousness of history and the reality is essential. Myself was unaware, was ignorant of what really happened in Hawaii. And when I met Dr. Sai and I realized the reality of your history, then I decided to ascertain what is the status of international law of the Hawaiian Kingdom in consideration of this history. And this is the reason why I have decided to get on board. Okay. Mahalo.
Mahalo, Auntie Don. At this time, we are going to reconfigure into a panel discussion. So the question and answer format will be, I'll have one question for the panelists, but people will be collecting questions that you can write on cards, and we'll be selecting from those questions. And due to time constraints, so we only have time for a few, so we apologize for that. So we will start the panel discussion right now.
Very kind gesture.
Okay, the first question. How will you compel the United States to participate in the proceedings as the indispensable third party since they did not last time?
So the question is, again?
How will you compel the United States to participate in the proceedings as the indispensable third party since they did not last time?
The Fact-Finding Commission of Inquiry does not include the indispensable third party. That was the reason why the tribunal made the recommendation to go to fact-finding so that the indispensable third party rule may not be or could not be the issue. And so there is no proceedings that requires the United States participation. There is no requirement.
Okay, next question. Why do laws of occupation apply if Hawaii is not at war or part of the Spanish-American War? I believe that refers to belligerent occupation.
Yes, as I tried to explain, the law of occupation also applies when occupation takes place without any armed resistance. So, occupation is a de facto situation which takes place when one state overthrows the government of another state and prevents this other state to exercise its sovereignty, which exists under international law. This is the only condition, is a factual condition. We don't need any armed conflict. We don't need any military resistance by the occupied country. So the law of occupation applies nonetheless.
I can just give you two examples of what Professor Lenzerini spoke to. In 1914, Luxembourg was a neutral state, and it was invaded by Germany in order to launch attacks into France. Luxembourg did not resist the invasion. That did not mean they capitulated and lost their country. That was regulated by the law of occupation, which Dr. Lenzerini was speaking to. So customary international law recognizes the neutrality of countries, which the Hawaiian Kingdom was. The Hawaiian Kingdom, there were 4 recognized neutral states in the 19th century: Switzerland, Luxembourg, Belgium, and the Hawaiian Kingdom. Our neutrality was in provisions of treaties. So when Hawaii's government was overthrown in 1893, the United States President Cleveland admitted it was an act of war. When you say that, it activates the law of occupation or the laws of war. Okay. Hawaii was then invaded again in 1898 during the Spanish-American War in order to fight the Spanish in Guam and the Philippines, very similar to how the Germans occupied Luxembourg to fight the French. But in both cases, Luxembourg and Hawaii, if they did not resist and had bloodshed, that did not mean their sovereignty was not secured and protected.
Okay, next question. And I believe this refers to the Baltic states. I'm just guessing here. Would a roll call of subjects of the Hawaiian Kingdom show the existence, its existence as a state? So in the Baltic states, Estonia in particular, the occupation by the Soviet Union was ended essentially by reestablishing the population on a list. And I believe that's what this question is referring to, establishing a roll call of Hawaiian subjects. Would that be a way to bring the government into existence.
Whether the Hawaiian people continue to be Hawaiian subjects despite the occupation, is this the question?
There is a debate in the community about the process of deoccupation, and there's one school that says that it's this re-establishment of the citizenry, and the other, which Keanu would advocate for, is military law. And so I think this question refers to the first one, which was used in Estonia, Latvia, and Lithuania. They had a massive roll call, and that distinguished the citizens of those countries from Russian immigrants living in those countries.
Okay, the law of occupation, international humanitarian law, does not call for the immediate end of occupation, because occupation law of occupation, mandates the occupier, who is in effective control of the occupied territory, to administer the laws of the occupied state. It is the problem that we have today is the fact that the United States did not administer Hawaiian Kingdom law. They were administering American law, which disguised the occupation. So the key here is to get the occupier to comply with the law of occupation, which has not taken place for over 100 years. Now, the International Commission of Inquiry will be looking at that as one issue, the effects that it caused with regard to Hawaii. Now, as far as nationality and a role, your nationality as a Hawaiian subject is not dependent upon you signing up on a list, but rather it is based on a legal term called jus sanguinis, which is you inherit the nationality of your parents or your grandparents that existed before the occupation began. So I'll give you an example. So an example would be, in the Hawaiian Kingdom, the word Hawaiian, see, we use the word wrong today. Hawaiian is actually a short term for Hawaiian subject, like British is a short term for British subject. You can be Mandarin or Ilocano and still be British. Now, English is the ethnicity. British is the nationality. And you can acquire British nationality back in the 1800s if you were born on British territory. It's called natural born, or jus soli. That's the legal term. Now, let's use an example. 1893, January 1st, a family was visiting from Italy. And this person's wife gave birth at Queen's Hospital. That child, born in January 1st of 1893, would have acquired Hawaiian citizenship by birth on the soil, but also Italian citizenship from the parents. That's a dual citizen. Sanford Dole is an example of that. Sanford Dole's parents were American, but he was born in the Hawaiian Kingdom, which made him a Hawaiian subject, and then he served as a judge on the Hawaiian Kingdom Supreme Court. So the issue of nationality using law is not based upon what you declare, it's what you are. And there are legal rules to identify that, right? Now, during occupation, though, occupation, its purpose, the law of occupation, its purpose is to protect the status quo of the occupied state. That's why when Hawaiian law says you can be born in Hawaiian territory and you become natural born, a Hawaiian subject, once a country is occupied, international law prevents that from taking place. Because if they allow that law to continue, then the occupier can send in their nationals, give birth on the soil of an occupied territory, and offset the national population. That's what's being taken up with the Jewish settlements in Israel, the issue of nationality by being born on Palestinian territory. In fact, In World War II, Poland, Germany was sending Germans over in an attempt to overwhelm the national population. So for Hawaii, to determine your nationality is not your claim, but whether it's your mo'okuauhau, your genealogy, that goes back to a Hawaiian subject, whether native, whether English, whether Italian. It's that nationality. So if that person in Italy, from Italy, gave birth to that child on January 1st, 1893, that child is a Hawaiian subject by birth. And let's say they go back to Italy January 15th, and they left. Did you know that the children or the descendants of that child in Italy also have Hawaiian nationality? Unless there is a law in the Hawaiian Kingdom that says no, but I can tell you there is no law that says no. So there are more Hawaiian subjects than we know of within this legal framework.
Yeah, just to very briefly, to further clarify, I would like to use a term which I used this morning for the students of the Kamehameha School. The occupation which took place at the end of the 18th century, 19th century, has frozen, to give you an idea, the existing situation. And this applies to the issue of sovereignty, to independence, and also to nationality. So the criteria to determine Hawaiian nationality remain the same. And nationality will flow in the same way that it would function in the absence of the American occupation.
There are a few questions here, the gist of which is, can you say more about the provisional government's ability to represent the Hawaiian state?
So this position that the provisional government has is it does not represent the people. It doesn't. It represents the state, but it just cannot claim to represent the state. But it can take necessary steps to represent the state if certain criteria are followed, meaning that the rights of the citizenry are not affected by this process. An extraordinary situation has arisen that would leave no alternative but to assume the chain of command. It's very, very focused and limited because during occupations, it is the occupier that is the responsible party to be the temporary government. It is not the government in exile or the provisional government. The only function of the provisional government, which you folks might find interesting because that's what 1893 individuals called themselves, the provisional government. And they weren't established by any voting process, but they tried to justify the necessity by claiming that the queen was a tyrant and they needed to take extraordinary steps. What they did, which was illegal, we followed the same rules but do it legally. When you assume the role of government, an acting government or provisional government, you also run the risk, if you don't understand what you're doing, you could be committing treason under the domestic law of the Hawaiian Kingdom. That's very important to know. So the limit of the provisional government is to expose the occupation. That's all. It's to provide for an effective transition when the occupation comes to an end. But this is precisely what Lance Larsen found himself in, was he was alleging that the acting government or the provisional government did not intercede to prevent the unlawful trial of him that led to his incarceration. But under international law and occupation, effectiveness is the cornerstone of administering the law. And occupation, its effectiveness does not mean you're sovereign. Normal international law, without getting into international armed conflict or humanitarian law, effectiveness is the cornerstone of countries when they're not occupied, because the government has to be effective. International law kind of throws, it's a reversal. You can have effectiveness without having title, and the occupied can have no effectiveness but have title. So it's a very complicated process, complex, and it is not something that we rushed into. We had to ensure that it was done correctly, because we would be the ones personally that could be held liable for treason. So it's a very careful process, and this has been, since the Larsen case, been acknowledged by other countries, and these issues would also be brought before the Commission of Inquiry. So what the provisional government is doing through the International Commission of Inquiry is not promoting its existence. Oh, it exists. It's addressing the fact that we have violations of international humanitarian law that has affected Lance Larsen, and by extension, all of us here. Because all of us are, in a way, Lance Larsen. And so is Federico as an alien in Hawaii. He is also supposed to be protected. So that's what the International Commission of Inquiry is all about. Can I touch on this? Okay.
I think we have time for at most 2 more questions. Again, there are a few questions that deal with the question of enforcement. What kind of enforcement mechanism exists, if any, for the rulings of international courts?
Okay, enforcement. Courts or commissions of inquiry do not have enforcement. I'll give you an example. In the state of California, the Superior Court in Orange County has no enforcement. What it does is it looks at the law, looks at the facts, and makes a decision. But it's not enforceable by the courts. What you need is the sheriff's department to execute the enforcement. The police department, that's an executive function, not a judicial function. Now that same situation applies at the international level. International tribunals or courts do not have enforcement. What their job is to do is to look at it through the law on what took place. Now, you don't have a police department or the sheriff's department at the international level. What you would have is governments themselves, sometimes military, but you also have other agencies at the United Nations, such as the Security Council, or you have the Human Rights Council. I mean, the issue of enforcement at this stage is secondary. What we are looking at is an issue to be looked into and articulated by a body that is neutral and also authorized. That's what's important at this stage.
Yes, what Keanu has just said is all the more true for commissions of inquiry, because these commissions don't have the competence to release binding judgments like courts. So what is important is the knowledge at this stage, is to spread the knowledge within the international community, because the knowledge is the first powerful weapon to obtain results, to move the international community towards realizing justice. So sometimes a judgment by an international court is less effective than a deliberation by a commission of inquiry. It depends on the content. It depends on the international visibility which a decision obtains at the international level. Then, generally speaking, Keanu was explaining that enforcement is a little bit more complicated at the international level than at the domestic one, just because there is no police force which has been established in order to control the behavior of states. in case of a dispute which is settled by an international court, there is a previous commitment by the states involved in the dispute to respect and implement the decision of the court. If a state does not respect its commitments, then many things may happen. The other states can try to force the country which does not respect its obligations to implement the decision, of course, through using peaceful means, but can be very much effective. For example, economic sanctions. For example, the interruption of any diplomatic relationship. The fact of sending away the ambassador of the state from your country. This kind of situations can persuade the other state to respect the decision of the arbitral tribunal, but there is not certainty in this respect.
Professor Lenzerini, your last answer referred to what can be done in the international community. I think this next question is a good closing question. What can Hawaiian Kingdom subjects do to kāko'o or support the restoration and support the independence of the government? To support this continued process of restoration?
Well, in my opinion, first of all, to believe in your belonging to the Hawaiian Kingdom. To be aware of the value of your identity and to do what you're doing right now. I am just an example. I am here tonight. I am an Italian citizen who, until a few months ago, totally ignored the reality of the situation of Hawaii. The more international support you obtain, the more the action of the Hawaiian Kingdom can be effective. But I repeat that the most important thing is not to surrender, is to continue to believe that you belong to the Hawaiian Kingdom and that you don't want to lose your identity as the Hawaiian Kingdom.
Well, I'd like to mahalo our panel and note that there are refreshments. There's me'ai mama outside, and they will be available for a little bit more. I realize there's never enough time to ask every question that we'd like to ask. But at this time, we have a special presentation for our panelists, for our guest.
Mahalo, Umi. You know, important Hawaiian occasions, occasions such as this, very high level, are always accompanied with mele. And mele are an important part of our heritage. Ola kākou ina mele. We live, ola na kupuna ina mele. Our kupuna live again in our mele. And there is an example of a series of mele or chants that were composed leading up to the February 12th, 1883 coronation of King Kalakaua and Queen Kapi'olani. They had already been in rule for 9 years, but after the 1874 election of Kalakaua, he eventually, in 1881, makes his way around the world, becoming the first sovereign in the history of the world to go around the world. Our people were very worldly, and so upon his return to Hawaii, with the completion of Iolani Palace in late 1892 and the setting of the coronation date, February 12th, 1883, 1882, 1881. Prior to that, a series of mele were composed in honor of Queen Kapi'olani. This one we do in honor tonight of our very, very special international guest, Dr. Federico Lenzerini, a mele entitled Mai Italia Ko Leinani. And this refers to the crown and the diamond necklace of Queen Kapi'olani worn in February of 1883. Mele that is said to have been composed by Mrs. Hannah Lili Kalani. Mai Italia Ko Leinani, from Italy, your beautiful crown adornments. Mahalo Anui. We want to recognize Kumuhura Kareo Trinidad and the students of the Hawaiian Ensemble here at Kamehameha Schools, Kapalama. At this time, to make another special presentation to Dr. Federico Lenzerini, we call to the stage the manager of the Ka'iwa Kilo Moku Hawaiian Cultural Center here at Kapalama, Jamie Fong, as well as Laiana Kanoa Wong, to make a presentation.
Aloha aina kākou, aloha. E ola ka Lāhui. Mahalo nui to everybody who came, but I want to give a special mahalo to our international guests who came all the way over from Italy, brought your ohana. And to me, it's reminiscent of the stories of Kamehameha Ekolu, the envoys that he sent along with Timoteo Ha'alilio. He needed the support of other countries to achieve some of these pieces. We had Sir George Simpson from England. We had the kako'o of our international alliances. And as we are relearning our history, reasserting ourselves as a Lāhui who is steadfast in aloha aina, we cannot think of a better gift to give you than the flag that was designed by the namesake of this kula, by Kamehameha himself, to be recognized as the Hawaiian Kingdom flag to be flown in the world. Please accept this gift of aloha aina. And we never forget you, bro. You have been oni pa'a, and what a great example as an alumni of this kula to do the work, to imi noi'i, to research, to challenge, to get it vetted, so that education can shine the light on our people, and our Lāhui will never be in the dark again. To Dr. Keanu Sai, our High Hawaii, e mau kona velo ana.
anui. Olu e pule pōku kākou ke ia manawa. A e ho malu kākou. Ke akua mana loa ei anō mākou ka poe o Hawaii nei me ke aloha, me ke kūpaa. A nui ko mākou mahalo ia oe ke akua no kou aloha ia mākou nei, kou aloha I ka Lāhui, Hawaii. Our Heavenly Father who has created this special evening, we raise up our voices with aloha to you, knowing that all the information we've received tonight will continue to be in our na'au as our ohana leave this evening to continue the discussions o pio with makua and kupuna so that we know who we are and that we continue that identity that is so important. You who have created us, we give you praise and glory. You who have created our pauahi and ali'i and our kula, we say mahalo. We ask for forgiveness for things that may not have been right, and we only ask for the things that are good in your sight. Take us home safely and help us to share the information that we have learned tonight. We ask for your guidance. Ha'awi mai ka ikaika, ka ho'ona awau, a me ka pono o ko mākou Lāhui Hawaii. Mahalo ke akua, makaino kau keiki hiva o Yesu Christo. Amene, amene, amene.
Mahalo anui on behalf of the Ka'iwa Kilo Moku Hawaiian Cultural Series, Kamehameha Schools Kapalama Social Studies Department, and the Parent Fund. Mahalo anui ka hele ana mai, e pupa kai kako me ka mea ai mama o waho. Aloha.